Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, hear, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, lawyers. Great to see lawyers in person. Welcome to the First Department. I will begin with a call of the calendar. First case on the calendar is People versus Johnson, and that is omitted. He was off. Again, first case on the calendar, People versus Johnson, and that's omitted. Castillo Zaire versus Citarella Operating is omitted. A. Nicholas is omitted. Then we have Cato International versus Gerard Fox and Cato International versus Fox Law. Those cases are going to be argued together. The Fox appellant gets 7 minutes and 2 in rebuttal. Cato International gets 7 minutes. People versus Anthony Cochrane. Appellant Cochrane gets 5 minutes and 2 in rebuttal. The people get 5 minutes. Lewis versus Pierce Bainbridge. Appellant Lewis gets 6 minutes and 3 in rebuttal. Respondent Pierce gets 8 minutes. 37 East 50th Street is submitted. People versus Cortland Allen is submitted. McLaughlin versus Arch Insurance. Appellant Arch Insurance gets 6 minutes and 2 in rebuttal. Cross appellant McLaughlin gets also the same, 6 minutes and 2 in rebuttal. Warren versus Silas is submitted. People versus Henderson is submitted. People versus Holmes is submitted. East 72nd versus the MTA. Appellant East 72nd gets 6 minutes and 2 in rebuttal. The MTA respondent gets 6 minutes. People versus Grant. Appellant Grant gets 5 minutes and 2 in rebuttal. The people get 5 minutes. And then last, we have an election appeal. Sakibu versus Diallo. Petitioner Sakibu gets 3 minutes. Diallo gets 3 minutes. Okay, first case on the calendar for argument, Cato International versus Fox. Let me first hear from Appellant Fox.
May it please the court, my name is Vitoni Vezai from Gerard Fox Law, and I'm New York counsel for appellants, defendants Gerard Fox Law and Gerard Fox. I'm respectfully requesting that Marina Bogorod, who has been admitted pro hoc vice, be permitted to argue these appeals.
Your application is granted.
Thank you.
Thank you, Your Honor. Good afternoon.
Good afternoon.
This is not one of those rare cases where the facts are so clearly uncontested that appellants can be legitimately denied their day in court. Indeed, this is not the take your eyes off the road by looking in your purse and injure someone type of a situation that the Andre court found so clear-cut as to decide the outcome right then and there. But this court need not even reach the merits of the underlying controversy because summary judgment here was procedurally improper and should be reversed on that ground alone. Respondent chose to move for summary judgment at the close of the pleadings without conducting any discovery. It chose not to attack the pleadings or their adequacy. These choices have consequences. Respondent chose to carry the summary judgment burden, which includes establishing the absence of any material tribal fact as to appellant's pending counterclaims and defense.
Let's assume that they establish the prima facie case. What is the triable issue of fact in this case?
The tribal issue of fact in this case, there are actually 6 tribal issues of facts. First of all, there are the misrepresentations themselves that induced the amended lease in the first place.
Why aren't those misrepresentations just puffery? If somebody told me, with respect to New York real estate, you know, this rent is below or above market, can I justifiably rely on that kind of puffery? Or do I just go ahead and, particularly lawyers, right? Lawyers should at least know that they should go ahead and check with a realtor or with somebody who has the knowledge of what the square footage is for that particular space or that area of New York.
Well, as this court ruled in PT Bank, the false statement of value, such as at issue here, are actionable when these statements concern value of timberland and its inventory used as a loan collateral. This is a long-standing rule of law in New York going back to the Jellis case.
Yeah, but counsel, we're talking about real estate and we're talking about an attorney. So again, the question again is, why is this not something that he could have simply discerned or learned about by just exercising some due diligence in investigating what the real estate prices were?
This is not something you can determine from a simple Google search, and the relative sophistication of the parties here is out of balance.
But is that the question? I mean, the question is really whether you can justify or reasonably rely on the assertions of someone who is trying to rent a space from you in New York City.
Yes, you can justifiably rely when you're dealing with a seasoned New York real estate professional who's representing to you, based on their knowledge of this particular office space, their history, how much it would be affected by the ongoing renovations, given the budget and the particular extent of those renovations. Taking these particular facts into account, these are representations of concrete present fact that can be
let's go over the representation. I mean, we're talking about basically two core ones, right?
Right.
One is how easily the space could be relet.
Right.
And the other one relates to the actual value, whether you are above or below market.
Right.
You know, if someone tells me, you know, you can easily rent the space, the follow-up question will be what? Like, what is the square footage in the area, in the building?
Right.
The surrounding area, right? You can't rely on somebody's opinion about my ability to relet a space.
Somebody with the peculiar knowledge of that particular space, how it's affected by the ongoing renovations, knowing the history of tenants, how it was relet in the past, somebody with all that combined knowledge, there's at least a factual issue as to whether the reliance was justifiable, especially because respondent moved without conducting discovery and didn't show that the due diligence wasn't done in this case. And it was their burden to show whether diligence was done per the Sokolow opinion by this court. So we're not talking about us being able to prove our case down the line. We're talking about a sufficient factual issue that would allow the appellants to proceed to discovery. And if I could address the second appeal for a second. This concerns appellants' purported waiver of discovery. In the middle of a global pandemic, summary judgment gets granted after pending for almost 2 years, despite all the uncertainty of last year.
Counsel, let me ask you a question. Did we ever, is there any evidence in the record that sheds light on how the landlord calculated what you owed to him or to it?
We have not conducted any discovery on this issue, and we think we're entitled to this discovery. We cannot be denied fundamental rights to discovery just because for 6 months after this decision was granted, we focused on mediation efforts. In the middle of a global pandemic, when we couldn't reach the opposing counsel, and once we reached the opposing counsel and tried to mediate, respondent abruptly withdrew from mediation and immediately said that they were ready for trial and certified that all discovery has been conducted,
Well, I
which
think
was
counsel,
untrue.
Counsel, I think the issue was the calculation and the fact, I believe there was no meter that was installed, and the meter was supposed to be installed. So the question was whether or not you could calculate the bills in terms of the electricity.
Well, first of all, the space was relet. So the trial court itself found that there were factual issues outstanding that needed to be figured out. One of them was calculation of damages. Because the space was relet, we're entitled to calculate damages and get discovery in that regard. But as to the counterclaim on the electrical charges, yes, there was no meter installed. We have a counterclaim where we still don't know what our damages are, and we're entitled to conduct discovery to calculate it. Thank you, Your Honor.
Thank you.
Thank you, Your Honors.
Thank you, counsel. Can we begin where we just ended? Did you ever install the sub-meters that would allow you to calculate the electricity that you now claim is part of the damages?
The submeter was not installed, Your Honor. It's not part of the
So
record.
how do we know what they actually owe?
Your Honor, we were appealing from summary judgment as to liability. Justice Bannon specifically,
Well, that's why I wanted to start from the back. So let's assume that we affirm the grant of summary judgment. And we then have to deal with the second appeal, which is the issue of the vacatur of the note of issue. And why, I don't understand, why was the note of issue not vacated?
the note of issue was not vacated because for 2.5 years, 25 months, excuse me, the appellants, defendants, had the opportunity to take discovery. They did not take discovery. They didn't take discovery after the complaint was filed for 5 months. They didn't take discovery after the summary judgment motion was filed in September 2018, prior to the pandemic. They didn't, Justice Bannon said discovery and all
But
proceedings.
you filed the note of issue stating that discovery had been completed.
We stated, consistent with what the certificate rendered states, that the note of issue was filed after the joinder of issue, it was filed after discovery known to be necessary to be completed, it was filed at a time there were
Known to be necessary was completed, but it had not been completed.
Your Honor, there is no discovery needed here. The electricity is some $10,000 on the 5 months, which is $548,000.
Well, tell me how you calculated it
The
then.
remaining $14 million due under the lease.
No, but tell me how you calculated the electricity when you never installed a
Pursuant to the lease.
sub-meter to measure
The
it.
lease says that electricity be calculated according to square footage until a sub-meter is installed. And that's how it was done.
Wasn't it your responsibility to install the submeter?
Yes, Your Honor. But if
You
the
did not
only
install
issue
the
here-
sub-meter.
If the only issue here on discovery is electricity, we'd be willing to waive the electricity. It's $10,000 on $548,000. It's probably $100,000 on the $14.5 million remaining on the lease through 2027. And by the way, the property hasn't been released.
Counsel, I'd like to go back to the waiver issue.
Yes, Your Honor.
Because there was never a preliminary conference held in the first place, so.
I
there are no-
apologize, I didn't hear that.
There was no preliminary conference that was even conducted in the first place. So no orders were issued, no violations of any discovery orders. So what's the evidence that discovery was waived? We didn't even have a preliminary conference here.
Your Honor, I think this case is very similar to Aconot v. Spruce Associates, which was decided by this court in 2020, also affirming Justice Bannon. And I'll note that Justice Mazzarelli was part of that panel. In that case, except this case is more compelling. In that case, Justice Bannon refused to vacate a note of issue or to permit post-note of issue discovery in light of defendant's failure to take discovery earlier. In Aconot, unlike the instant case, defendant had sought certain discovery prior to the note of issue, specifically some Facebook discovery. But Justice Bannon found that defendants knew of their need for this and had taken a deposition 5 months earlier and never followed up on it. This isn't 5 months here, Your Honor. This is from May of 2018 through.
Wasn't the case being mediated through the commercial division's mediation
It was a short
process?
mediation, which got nowhere, Your Honor. And during the mediation,
No,
Justice
but
Bannon specifically.
you're saying why they did not request discovery? I mean, you were trying to settle the case for a significant period of time, correct?
Five of the 25 months,
Well,
Your
you know,
Honor, at most.
one
And Your
thing I-
Honor, I will note that. I'm
excuse me,
sorry,
if you can hear me, but I think this is on, yes. One thing that you seem to be ignoring is that filing a motion for summary judgment stays discovery.
Your Honor, it did not hear what the CPLR says. It stays it unless the court orders otherwise. And by order dated February 5, 2019, and if I may approach or hand up that.
No, that's all right, you can keep it.
Justice Bannon specifically held on February 5th, and I'll read it. Proceedings in this action, including discovery and motion practice, shall not be stayed during the ADR process. The motion for summary judgment is adjourned until April 3 for the status conference.
Well,
So this is not a pre-printed form as opposing counsel claims in their papers. She specifically said, continue with any discovery. She ordered that. So there was no stay. There was a stay effectively for about, I think it's a month. I can get the exact date. But that was it. The rest of the time, the judge told them, take discovery if you need discovery. Go forward with discovery. There's no dispute they signed the contract. There's no dispute with the leases. There's no dispute about anything here other than the electricity, which, again, they didn't demand that the submeter be put in until afterwards. And the lease says it will be put in at some point. There's no specific time is of the essence. There's no date on it. There's no nothing. And, Your Honor, frankly, on $14 million, we'd be happy to waive the maybe $10,000 or $100,000 in electricity fees if that would resolve the issue.
Well,
we can go
the
forward.
problem is
Nothing.
we're not in the process of mediation. Maybe that's something that should have been resolved during the mediation before a referee or before one of the JHOs, right? But
But-
now we have an issue with respect to the certainty of the damages that you asserted. Are you entitled to the $547,413.16? So part of the question that we have is, okay, so how do you determine without sub-meters that you were required to install, how do you calculate the electricity without those meters?
Your Honor, I don't think it's possible to calculate bluntly because there was no submeter. It was done based on a certain amount of electricity per square foot, consistent with the lease, which said at some point, no specific date, you put in a submeter. So they are allowed, under Justice Bannon's decision, to put in evidence on their counterclaim for breach of contract for not putting in the submeter. They can put in their evidence as to what it would cost for the submeter. We can put in our
Oh,
evidence.
but you were the movement for summary judgment, so you got to establish your case before the burden shifts to them to create tribal issues, right?
She did not enter summary judgment as to dollar amounts. She entered it as to liability, saying they are liable under the lease for not paying the amounts under the lease.
Okay.
Of that 547, as it shows, 537 of it was everything except for the electricity.
Okay.
So whatever
Thank
the
you,
dollar
counsel.
amount is going to be determined at trial, according to Justice Bannon. She said that the counterclaims continue, the first two counterclaims, breach of contract continue, so they can prove that the electricity is not, it should have been 5,000 instead of 10,000, whatever the number.
Thank
for
you
that
so
period.
much, counsel.
Thank you, Your Honor.
Okay, let me hear from Fox. You got 2 minutes rebuttal.
Thank you, Your Honor.
So tell me, what discovery do you need?
First of all,
They seem to be very clear that,
sure.
as to the amount that was arrived at.
Well, we need discovery. Is this a foregone conclusion that the summary judgment non-liability is getting affirmed?
No, we ask questions and we cross-examine.
Sorry.
We'll decide when we deliberate.
If summary judgment is reversed, we need discovery on the fraud counterclaim. We need to depose the broker that we allege was in conspiracy with this landlord to defraud the client to enter into this lease. We need to take full discovery on the fraud claim, but even if summary judgment is not reversed, we need full discovery on our damages exposure, and the trial court confirmed in her summary judgment order itself that this is a dispute of fact of how much damages we owe under this lease. There's also a factual issue as to our counterclaim, which respondent cannot waive our counterclaim, as to how much exposure they have on the electricity issue. And respondent raised the Econaut case, where the party that was held to waive their discovery rights because they moved for summary judgment. So they conceded they didn't need any more discovery. There's no such evidence here, Your Honor.
Okay,
Thank you so much.
thank you. Thank you both. People versus Cochrane.
Okay.
Okay, ready?
Yes, Your Honor. Good afternoon. May it please the Court. Ariel Reed of the Center for Appellate Litigation for Mr. Cochran. Mr. Cochran was entitled to a 3:30 hearing on his motion where two jurors submitted affidavits after trial attesting to improper conduct by lawyer jurors on the panel who held themselves out to be experts on the law of intent and browbeat their colleagues into accepting their expert legal opinions.
I read that totally differently. That's weird. My reading of the record was totally different from what you just said. I didn't see anything in those affidavits where they claimed that the two attorneys, and I'm assuming you're referring to the two attorney jurors,
Yes, Your Honor.
browbeat them into anything. I thought that what the affidavits had stated was that these two individuals stated that they were attorneys and questioned the two individuals who submitted the affidavits, their understanding of the judge's instructions to the jury. I didn't see anything about browbeating them.
Well, Your Honor, I believe that the affidavits that were submitted by the jurors go a little bit farther than that. One juror stated that after her question to Judge Burke was answered, she believed that Mr. Cochran was not guilty of robbery, and she was told by the other jurors that she didn't understand, by the attorney jurors, I should say, that she didn't understand the law, that if she didn't understand the law, they would explain it to her, that she was wrong.
Was she 100% certain as to what the law was and whether she was in fact interpreting the legal issues regarding intent correctly?
Your Honor, it's hard to say whether she believed that her interpretation was correct, and she was whether objectively it was correct.
That's what she stated in her affidavit.
In the affidavit, both jurors stated that the only reason that they changed their verdict was because they were told by the attorney jurors.
But they don't cite to any specific misconduct by these two attorney jurors. So what is the misconduct that they claim in the affidavit? Because I didn't find it.
Your Honor, the misconduct that they're claiming occurred here was these two attorney jurors, rather than allowing the jury to make a decision based on the instruction of the court, telling jurors who disagreed with them that those jurors did not understand the law by wielding their professional experience.
But how, counsel, how is that different? I mean, I've had jury trials that I presided over, where the jurors, I mean, you can hear them, from the jury room screaming at each other regarding interpretation of facts, you know, how can you believe that? You know, I mean, they get pretty intense. So there's no misconduct. I mean, jurors have strange ways to arriving at a determination. They ultimately do.
Yes, Your
That
Honor.
doesn't make a misconduct.
And in that situation, that's totally fine. Our law allows for jurors to disagree and to disagree vehemently. The problem is when jurors who have specialized knowledge about some material issue in the case then inject that specialized knowledge and tell other jurors, you have to rely on my specialized knowledge because I'm an expert in this area and I know what I'm talking about. It's one thing for jurors to just have different opinions and different interpretations. It's another thing for jurors who do have specialized
Well,
knowledge
first of
to
all,
use
I
it.
don't know that that's what these two attorney jurors stated. Second of all, why is it that if you're a juror, I thought the instruction was by the judge also that, you know, no one really has any specialized knowledge. But even if you're a juror, going back to what Justice Acosta stated, why would I not just reject that? I mean, you're a juror, so don't you have that ability to say, I don't care what your knowledge, you claim your knowledge to be, I'm not going to follow it, just like with real experts who testify at trial?
Theoretically, Your Honor, yes, any juror can say, I don't care if you're a doctor and you're telling me that what this testimony was is wrong, I'm just going to follow my gut. The reason that Morag and the Court of Appeals has laid out this standard is because it recognizes that that is not human nature. If you have someone who's saying, this is my area of expertise, I'm telling you this, a lay juror is not going to, you know, likely going to say.
So this is great for attorneys here because I think everybody would agree here that no attorney should ever be on a jury. And certainly a judge should never be on a jury.
This is not a time to get out of jury duty.
I don't think that's the standard, though, Your Honor.
But I think that's, you know, that's where the argument seems to be going. And again, I'm looking at the affidavits, and I really don't see that this is what occurred. And I also thought that wasn't there some indication that perhaps these two attorney jurors were not the only jurors who were actually questioning the two jurors who submitted the affidavit, their understanding of the law?
Yes, Your Honor. It's not clear how many jurors were on what sides, but I do want to note, as to your point, that's the entire reason why during voir dire, judges ask people with specialized knowledge, doctors, lawyers, judges, can you set aside your specialized knowledge and decide the case purely based on the facts in the law or the law that I provide? And every juror, whether they're an attorney or a judge, has to say yes in order to be seated on the jury.
Okay.
And so if they're going to say yes, then we would expect that they would follow that promise that they made during voir dire. Thank you.
Okay, thank you, counsel.
Good afternoon, Your Honors. Dana Poole on behalf of the people. In this case, there was no extraneous information or evidence introduced into the jury deliberations by the attorney jurors. Nothing in the motion affirmation or the attached affidavits.
So why do you think that these two, Johnson and Vidal, felt somehow that they needed to say something about how they were treated by these two particular individuals who happen to be attorneys? I mean, they singled them out, right? Mm-hmm. It doesn't mean that other jurors were not going at it with respect to what the law was, well, particularly the law on intent.
Well, it does sound like it was more than just the two attorney jurors who were arguing with them.
Right.
And both of these the complaining jurors, indicated that they came to the assumption that these attorney jurors must have some sort of expertise that they didn't have. But notably, the attorney jurors never asserted that. Even if you look at the affidavits and the letters and that they never asserted that. They didn't lie about being attorneys. They said so during voir dire. One of the complaining jurors said, you know, when one of the attorney jurors was very certain about his opinion on how to interpret the judge's law, she said, well, what, are you an attorney? And he said, yes. So they worked themselves into some belief that maybe their interpretation was wrong, and they caved or they were convinced. One of the jurors says when she voted guilty, she thought she was following the law. But later she learned what sentence was associated with that law, and she found that unconscionable, and she felt terrible about her part in this
So
process.
she felt there was guilt there was enough evidence beyond a reasonable doubt, but they just disagree with the consequence of that decision. in terms
That
of
was,
sentence.
I think that is a fair interpretation of Johnson's letter and affidavit. I think
So
that.
here's my question is therefore, it's a fair interpretation of Johnson's letter. We're kind of speculating as to perhaps why they voted the way in which they voted. Why not hold a hearing? Is there anything that would preclude the trial judge from now holding a hearing based upon the affidavits which have been submitted?
Well, the assumption is that judges don't delve into the jury deliberations. They are secret, they are confidential, and we just have a system where that is the intention. And so when you have a situation like this, where the absolute worst thing that may have happened here is that two attorney jurors insisted that they were right and somehow indicated that they knew they were right because they understood how to interpret a judge's instructions, and perhaps they were berating and belittling and demeaning and condescending. But none of those things, even if
Are you
shown to be
suggesting
true,
that that's typical lawyer conduct?
one hopes not, but it's certainly not unheard
But you
of.
said the absolute worst. That's pretty bad. I mean, doesn't that then reflect upon whether or not the defendant was in fact afforded a fair trial?
Well, the fact that jurors have strong disagreements and strong feelings, that is an acceptable way of
Yeah, but
deliberating.
what's concerning here is that you have two attorneys claiming some specialized knowledge about what the judge instructed them that pretty much was pushing the rest of the jurors around with respect to that knowledge.
Well, they weren't alone in that belief. There were other jurors who also agreed, and what they were arguing
But
about.
doesn't that call for a hearing? I mean, isn't that the very reason why the judge should find out what exactly went on? I agree. If you just have jurors yelling at each other regarding how each of them were wrong about some judicial instruction, I get that. That's not a problem. But here, you have a juror, at least two jurors saying, I felt the other way, but this guy who's a lawyer is telling me I'm wrong and I'm relying on him rather than the judge. Isn't that a real problem?
Well, because what the argument is about is how to interpret the judge's instructions. This isn't a case where the lawyer is coming in and saying, look, that judge doesn't know what he's talking about. Let me
How do
tell
we
you what
know
intent
that?
is.
I mean, that's the whole point. How do we know that without a hearing?
Because
And,
it's not.
Not for nothing, these two attorneys probably got the law wrong. And they probably were giving the other jurors the wrong interpretation.
Well,
of
what-
the
We
law.
get that
what
all
they-
the time at the appellate division.
But what they did in this case was they did what they were supposed to do, which was they sent a jury note asking for clarification. The judge gave that clarification, recharged them. They went back in the jury room, and then they sent a note saying, could you give us the recharge again, but really slowly so we can take notes? And after that, they went back into the jury room. The two other jurors were convinced for whatever reason. They agreed that he was guilty. They were polled afterwards.
Okay.
So actually, the jury here did exactly what it was supposed to do.
Justice Mazzarelli has a question.
I think you actually just mentioned it. I was going to ask you if the court individually polled the jury. I
They
thought that
did.
the court had done that.
Yes, Your Honor.
Did these two jurors express any hesitation at that point?
Absolutely not.
Okay, thank
Thank
you,
you.
counsel. Okay.
Thanks, Your Honor. I just want to go back to a point that both Judge Acosta and Justice Weber have raised, and is the fact that a lot of this is speculation. All Mr. Cochran asked for is a hearing. At that point, the jurors could have come in, they could have said, you said exactly this is how I interpreted, this is what I meant by it, and the judge could have hashed it out there. We didn't even get to that point. The judge, in fact, did not even allow the prosecution a chance to respond to the motion. It got the motion in the morning, read it over lunch, and ruled on it in the afternoon without any sort of process, without any sort of inquiry, without even a response from the prosecution. That's not process. That's not discretion.
Counsel, can you address counsel's argument with respect to the fact that the two attorney jurors did not provide any extraneous information, which is unlike the case in Marat? Can you address that?
Yes, Your Honor. The jurors here did not provide any sort of evidentiary extraneous information, but the two cases that respondents cited in their brief dealing with attorney jurors explaining things about the law were cases that were decided after a hearing. So it's not a fact of law that unless there's some sort of evidentiary dispute that you're not entitled to a hearing. In both this court's case, 23 Jones Street Associates v. Beretta, there was a hearing held where attorney jurors made statements about the law. In Swartz v. St. Mary's Hospital of Amsterdam, a third department case from 2012, there was a hearing where the attorney jurors made statements about the law. And I also want to note as well that the appellate record is incomplete with respect to Juror Johnson's affidavit. We're missing a page of the affidavit. So what the prosecution is asking this court to do is say, we don't need a hearing based on an incomplete affidavit by one of the complaining jurors. And we don't know what was in that affidavit. The court does, but the court didn't order a hearing. And so we're here kind of flying blind in a sense, and all Mr. Cochran asked for is a hearing. He was entitled to that based on the pages of the affidavit that we do have, and we ask this court to remand for that hearing.
Thank you. Thank you, counsel. Thank you both. Lewis versus Pierce.
May it please the court, my name is Neil Brickman of the Law Offices of Neil Brickman, PC. I represent plaintiff appellant Donald Lewis. This appeal is from a decision of the trial court which improperly granted, without even addressing or actually considering the claims asserted or the factual allegations of the amended complaint, the defendant appellee's pre-answer motion to dismiss. With respect to Judge Masley's dismissal of the Judiciary Law 487 claim, her decision does not even substantively address that claim at all. She merely announces that Ms. Connolly's deceit consisted of pre-litigation statements as to which a qualified privilege applied, and litigation statements as to which an absolute privilege allegedly applied.
Well, did Conley have a good faith basis for anticipating litigation?
She did, Your Honor, but it's completely irrelevant to the Judiciary Law 487 claim.
Tell me why.
Because a Judiciary Law 487 claim is premised upon an attorney's deceit of a court or an adversary.
What was the deceit?
The withdrawal stunt, Your Honor, which consisted of Ms. Connolly asking, it happened to be me, to withdraw a complaint that was filed because she...
And you decided to do it on your own, right?
No, I didn't, Your Honor. I did it because we were exploring the notion of mediation. We had said, we'll do mediation, but the opening number in that mediation has to be $1 million, and that we wanted to settle between $1 million and $5 million. She wrote, and this is all in the complaint, starting at the record 204, paragraph 101 of the amended complaint. She said, I can get you to that number to start a mediation, but I need more time. And in order for me to get you to that number, I need you to withdraw the complaint you have filed. We said, fine, we withdrew the complaint. Yeah. She thanked us for withdrawing the complaint, and several hours later, that complaint, which she asked us to supply a copy of to her, appeared as an exhibit in a Los Angeles complaint alleging civil extortion and claiming...
I mean, I agree those are pretty sharp tactics, but why isn't the test whether the statements that she made that induced you to withdraw the complaint and share it with her were pertinent to the litigation?
No, Your Honor, and that's the problem with the decision below. It conflates this notion of exceptions to the privilege, and we'll address that when we talk about the aiding and abetting count. But here we're talking about a Judiciary Law 487 count, which is premised on an attorney lying or deceiving another attorney or the court. In this case, Ms. Connolly lied.
So you're saying that goes beyond the zealousness responsibility of an attorney?
Your Honor, and
It sounds like you're lowering the standard so that pretty much half the lawyers that appear before us that engage in what some characterize as scorched earth tactics are going to wind up in trouble.
No, respectfully, Your Honor,
Tell me why not.
the reason why not, Your Honor, is because in this case, Ms. Connolly understood, or so it's alleged in the complaint, which must be accepted as true, that her clients were contemplating starting an action in Los Angeles. That action in Los Angeles asserted that the withdrawal of the complaint, which she had requested, was part of a civil extortion scheme, and it certainly was not that, and Ms. Connolly knew that, and as proof, alleged proof of this civil extortion claim, they attach as an exhibit the withdrawn complaint, which Ms. Connolly had asked for us to provide a copy. Now, if Your Honor, please, we can get into, so to answer...
Counselor, if I may, I'd like to know, how did you set forth the damages in the complaint from this alleged deceit? And I'm referring to the 487 claim.
Yes, Your Honor. We set forth the damages by saying that, but for this deceit, the national defamatory campaign that came out of the Los Angeles action, which was released by Pierce Bainbridge to the press with the the exhibit of the withdrawn complaint, calling my client an extortionist, a terrorist, a credibly accused sexual predator. Those damages and that claim don't exist if Ms. Connolly hadn't set up, through this deceit, a 487 claim.
And then just a follow-up question. Once a draft of the Lewis 1 complaint was sent, why didn't Connolly have a good faith basis that litigation would occur since the draft of the complaint was sent?
She did. The draft of the complaint was sent in March, Your Honor. This, what we call the withdrawal stunt and the LA action, occurred on May 15th. So again, whether or not these statements, the withdrawal stunt statements, were privileged because they were in anticipation of litigation is completely irrelevant, because by definition, a Section 487 claim requires there to be a litigation or a pending proceeding, and the deceit occurs in that setting. So if you were to say you can't have a 487 claim because everything, a lie, was in a proceeding or an anticipation of litigation, you effectively eviscerate the 487 claim. There can be no 487 claim if you immunize statement made in anticipation of litigation or as part of a litigation. Okay. And Justice Acosta, your question is a great question, which is, isn't this just jealous advocacy? No, it's lying and deceit which formed the platform, the runway, if you will, to a national defamatory campaign to smear and discredit my client.
Okay, thank
He
you,
was
counsel.
labeled an extortionist based on the civil extortion claim which Ms. Connolly set up and knew to be false.
Thank you, counsel.
May it please the court. My name is Marion Rice, and I represent Ms. Connolly and Littler Mendelson in this matter. If I could jump off from the bench's questioning of my adversary here. This is one of the few times where I have a complaint that is so specifically alleged that I'm happy to accept the allegations as they say. If we look at page 204 of the complaint in the record, we have exactly what the conversation was upon which the claims against my client are predicated. And if we look at page 204, Mr. Brickman puts down in detail the outline. At 11:32, my client says, Mr. Brickman says, having heard nothing further from you, I'll be filing the complaint in 5 minutes. My client replies, I can only offer that my client believes a 7-figure number can be reached but cannot agree to an opening offer of 7 figures. A few minutes later, she writes, not sure if you filed yet, but if you can get your client to hold off, the parties are in conversation and could get to Lewis's number if you provide more time. The response from Mr. Brickman was, I was able to get the complaint withdrawn and removed from the case docket. See below. If your clients make the commitment that we discussed before the close of business today, we will mediate on the 24th. My client responded, thank you. That's the exchange upon which this Judiciary Law 487 claim is predicated, and that is not actionable under the terms of the statute. This is not the type of conduct that the penal statute of Judiciary 487 was intended to oppose. Now, if I could also, from that point, Mr. Brickman predicates the fact that the Los Angeles fiasco would have never occurred. That's not the case. When Mr. Brickman had not heard back from my client that same day.
Oh, by the way, is 487 meant to regulate conduct in California?
No, sir, it is not. It is
It's
not.
conduct in New York.
Correct. In the New York State courts. There are cases that even say it does not apply in the New York federal courts. So when Ms. Connolly then, that same day, says to Mr. Brickman, and he quotes it in the complaint, she has no news to report about the mediation. The client, meaning Pierce Bainbridge, is acting on its own and not listening to her advice. If Mr. Brickman wants to know what is going on, he should contact the Pierce Bainbridge partner that he was dealing with before she was retained. This is not deceit. This is an attorney whose client is not listening to her. And unfortunately, that's what occurred after that. There is nothing in this record, and Judge Maisley said it best. There's nothing, it's just saying over and over again that Ms. Connolly colluded doesn't make it so. You actually have to have facts to do that. There is nothing that ties her to the complaint. Yes, Mr. Brickman sent her a copy of the withdrawn complaint. She gave it to her client. It did not create the morass of back and forth between the two gentlemen, the plaintiff and Pierce Bainbridge, that occurred in the papers after that. As a perfect example of that, too, is once again, Mr. Brickman has provided it as Exhibit D to the complaint in the record. Exhibit D is a 20-page chart of the falsehoods that were contained in the Pierce Bainbridge Los Angeles complaint that was done without my client's input. In it, he lists 43 separate statements that are false. Only one of them is this issue with the withdrawn complaint. To say that Pierce Bainbridge would not have entered into this fight with Mr. Lewis but for the withdrawn complaint is just speculation and sheer fantasy, really, given what's gone on between these two parties. So there is no basis for the Judiciary Law claim. The defamation claim, I think the privileges knock that out as it is. The intentional infliction of emotional distress claim, you cannot rest upon what otherwise would fail as a defamation claim in order to try and sustain an intentional infliction of emotional distress. And the disfavored tort of prima facie tort simply cannot be sustained under the facts that are presented against Ms. Connolly. Flat out, she told Mr. Brickman, I don't have control of my client. It's in the complaint, which we have to accept on the four corners on this motion to dismiss, and there's no basis for the claims asserted.
Thank you.
Your Honors, if I could, I'd like to first address Justice Acosta's question, which was, does it regulate conduct outside the boundaries of New York? The answer to that question is it certainly does, but it doesn't matter in this case. The conduct occurred in New York by a New York attorney, and what no one is talking about is that the first cause of action of the LA complaint was civil extortion, which indicated that the complaint that was withdrawn at Ms. Connolly's request was part of this larger scheme to extort a settlement of, they say in the complaint, $65 million.
But that's how you characterizing. The explanation that I'm hearing is you have a lawyer who has no control over her client.
Then she should not be speaking for that client, Your Honor. And when that client
You mean you're being in control of every client you represented? I mean, I litigated for 20 years. I never had control over every single client I had.
Your Honor, both of us wish we did, and neither of us did.
Exactly. So
But
the
here-
question is, are we going to be liable on the 487 because we have a client that refuses to listen to good, sound advice?
No, Your Honor, if that was in fact the case, but that's not what happened
But
here.
wasn't that communicated to you? I mean, based upon what your adversary just read and from the complaints, it appears, or from the emails, it appears that it was communicated to you that Ms. Connolly could not control her client.
Your Honor, that was a day after the complaint when I asked her very specifically, and you should look at that email, I said, did you know that this was in your client's contemplation? And Ms. Connolly never responded to that question. And the allegation of the complaint is that Ms. Connolly knew about it.
But that's speculation. I mean, sometimes, she engaged in a good faith conversation with her client. You want her to disclose to you what in effect is protected conversations between
Not-
she and her counsel.
Not at all, Your
How
Honor.
convinced the counsel was with respect to that advice. That's not proper.
Your Honor, the complaint also alleged that Ms. Connolly, in furtherance of this plan, requested a copy of the withdrawn complaint. And it says she requested a copy of the withdrawn complaint so that her client can attach it and an exhibit to a civil extortion complaint and allege that the reason that that complaint was withdrawn was as part of the scheme, that allegedly they had called our bluff, and that once we withdrew it and we refiled it, that was part of this terrible extortion. I see my time is up, Your Honor. Can I have a few seconds to deal with the aiding and abetting claim, or should we just rest on the brief?
That was well briefed in the brief that I've read, at least, so we don't
Thank
need
you
to
very
go
much,
into
Your
it.
Honors.
Thank you. Thank you both. McLaughlin? Go ahead, counsel.
Thank you, Your Honor. John Schapp on behalf of the appellant Arch Specialty. What the plaintiffs urge here and what the lower court decided was that an insured who is covered by more than one insurance policy gets to pick and choose how they're going to try to collect. That there are no rules about that and what you have to do. The problem with that is The Court of Appeals has specifically ruled to the contrary in the BP air conditioning case, which is cited throughout my brief. In that case, the court decided that One Beacon Insurance owed additional insured coverage, that BP air conditioning qualified as an additional insured under the policy in question. The court, after making that determination, ruled that the next thing we have to address is the priority of coverage. The court said that this court had erred in deciding coverage without all the insurance policies being before the court. The court held that a court must review and consider all relevant policies at issue before any determination as to amounts owed could be reached. Now, the court held that because in that case there was no other policies before the court, that no other insurers were parties to the litigation, that no determination of priority of coverage could be reached. The finding that the insurer was obligated to pay the insured's defense costs was reversed, even though coverage was decided as a matter of law. Here, there's only one other policy and one other insurer party before the court, but we do have all the policies here. So I submit the court can determine priority of coverage here as a matter of law. But even if you disagree with that, because the other insurers, or not all other insurers, are before the court, then judgment still has to be...
Isn't that what the underlying basis of the BPA conditional court case is? Or holding, namely that, I mean, I can quote from it, it says, because none of the other insurance carriers are parties to this declaratory judgment action, and no other relevant policies have been submitted. You're saying in as much as the policies are in the record, we can in fact determine it, right?
I think we do, Judge, here in this case, but even if you look at the first part of the question, or the first part of that statement that you just quoted, which says that the other parties are not, or that the other insurers are not
parties, right.
which is the same case here, then the judgment still has to be reversed here, because there isn't the parties necessary in order to enter a judgment. And that's what the BPA court...
So I thought that the Supreme Court found that the priority of coverage argument was waived because it had not been brought up in the motion for summary judgment, which was actually a motion in limine.
Well,
Wasn't that what the ruling was?
the ruling was that that aspect of the motion in limine was, in fact, a second summary judgment motion.
Right, but you
And
had
as
not
su-
brought up, you did not bring up, or the issue as to priority of coverage, that had not been brought up.
That had not
Therefore,
been-
they deemed it waived.
I'm sorry.
So therefore, it was deemed waived, no?
I don't think it's deemed waived, Judge.
No, I'm saying that's what the court ruled, right?
I don't think she said it was waived. She said, I am not going to consider it because it was not raised. And therefore, I view this aspect of your motion in limine as a second summary judgment motion. And because that is not generally allowed, I am not going to consider that motion. However, the issue was not waived by doing that. It was waived in terms of summary judgment. And I think the case law is clear, and I've cited it in my brief, that that does not act as a waiver either on a motion for a directed verdict or a judgment notwithstanding the verdict, which is what we have here. So while I don't think the judge ruled exactly what Your Honor suggested, I think the waiver was only...
Well, if the court says you didn't raise it,
Right.
that sounds like a waiver argument or statement.
Failed
right?
to make those arguments in its motion for summary judgment.
Right, so it was,
And so then it went into an analysis of newly discovered evidence, et cetera, and said that it did not meet that, that standard.
well, and I think that's, the point of that, Judge, is though she felt that there was a second summary judgment motion, which doesn't waive the argument completely. It only waives it in terms of making a second summary judgment motion.
Okay, and then she looked at the actual language in the policy stating that it stated that when either the underlying insurance does not provide coverage or the limits of underlying insurance have been exhausted. That Arch Specialty's policy required it to defend under those circumstances.
Well, Judge, and since we brought up the specific question of waiver, the question of defense costs was explicitly waived by the plaintiffs in this case. And if you look at how that all happened.
I'll let you raise that in rebuttal, okay?
Thank you.
You're way over your time. So let me hear from the McLaughlin Cross Appellate.
Good afternoon, Your Honors. Daniel Hansen for the plaintiffs McLaughlin. And just picking up where Justice Weber left off in terms of Judge Crane's decision, she got it mostly right. She saw the procedural shenanigans that were going on here. We had a summary judgment motion that was decided a couple of years ago by this court directing a trial on two discrete issues. Those two discrete issues were submitted to the jury. A plenary trial was held. Witnesses were called. The defendants put on witnesses. And a verdict was rendered. But before then, essentially the day of trial, defendant shows up with a motion in limine that we're all familiar with over all the years of trial, to exclude or admit evidence. But the thing they're calling a motion in limine is really a motion for things they may have wanted to raise when they were here 3 years ago, or 4 or 5 years ago when they were before Judge Crane on the prior motions. So then you have that complete mess dropped in the trial judge's lap on the day of trial, and that's followed by a 4404 motion to set aside the verdict as against the weight of the evidence. First time I've seen a case in 30 years of practice where there's a 4404 motion to set aside for a JNOV where the trial transcript's not attached. There's nothing alleged here that the jury got something wrong, that the judge did something wrong. If there was, we'd have a trial transcript, we'd have some indication, here's what the jury got wrong. We have a 4404 motion without any attack that the jury screwed something up.
But the court deemed that motion to be a motion to fix damages, right?
It was my cross motion, Your Honor.
I see.
It was my cross motion to fix damages based upon the calculations from the case that I had tried back in 2012, I'm sorry, in Supreme Queens, that resulted in this.
Okay.
So now here we are, 9 years later, still chasing this insurance company to get the McLaughlins paid their on the verdict. The McLaughlins took a real risk of getting an assignment of these claims. They took a real risk in trying this case. They took a real risk in Queens, and they took a real risk trying the case before Judge Crane a year and a half ago, 2 years ago. And they won. And they won. And what we have now is all these odd procedural maneuverings where you have a motion in limine that's saying, well, you should decide priority of coverage. You have these motions in limine that are really not motions in limine. You have JNOV motions that are not JNOV motions. You have these arguments raised for the first time on appeal. For example, there was nothing pled about defense costs. The first time any court's ever heard of that is in the appellate briefs.
So, counsel, what is it that Judge Crane got right, and what is it that she got wrong?
The coverage issue was absolutely right. The waiver issues, and it is waived. If you didn't raise it, that's a waiver. The issue that we take issue with, the issue is really the calculations. Everything else, she followed what happened in the case. She recognized what was done, or what was trying to be done by the JCP justice and then her with this nonsensical motion in limine. And then she realized, but the calculations were wrong. And the calculations were wrong because before AIG paid the $2.4 million, there was a period from the time that the judgment was entered in Queens in 2012 until that 2.4 was paid. And there's interest due on that period. There's interest due on that period from the time that the judgment's entered till the time that the judgment is in part paid. So there's interest on that 2.4 for that period that's set forth in the briefs. The other thing that the other mathematical really point, almost ministerial, but not quite, is the assessment of the amount of $175,000 or $275,000 versus $625,000.
Does that amount remain unpaid, right?
Yes, that's the amount that's unpaid.
Okay.
And other than that, the decision's laid out. It's laid out. Judge Crane had the case on motions that came up to the appeal on the first time around. We got assigned to, we were in the JCP part, got reassigned to her because she was familiar with the case. She saw what went on, and she dealt with it appropriately with, like the court says, the waiver, and knowing what was trying to be done to the courts and also to my clients. There was a hustle. And the hustle was these motions eliminate, which is really summary judgment motions, all the things we forgot to raise back a few years ago when we were standing before you then. And then a JNOV without a trial transcript. That's not JNOV by any stretch of the imagination. There was nothing complained of about what this jury did wrong because they got it right. They were given two questions by this court, two very discrete questions. They were agreed upon by the parties. It was submitted. They came out against the defendants, and here we are again today.
Okay. Thank you,
Your Honor.
Thank you, counsel.
To be clear here, there is nothing outstanding on the judgment. There has been nothing outstanding on the judgment since October 24, 2018, when Mr. Hansen executed, acknowledged a full and complete satisfaction of judgment, saying the judgment has been fully satisfied and paid, and no sums remain unpaid.
I thought that on August 18 of 2014, the plaintiffs filed a partial satisfaction of judgment in the underlying action, right? That's the Queen action.
Right. There was
indicating that only $275,000 remain unpaid on the judgment. And that's
as
on
of
the record at 462, right?
that was as of 2014. As of 2018, there was zero outstanding. The original judgment was for 3.85. There were two partial satisfactions of judgment filed, one right away, one in 2014, then a full and complete satisfaction of judgment in 2018, and that's why there could be no recovery under the claim for insurance law 3420A, because there is a complete satisfaction of judgment. They cannot recover on that. And to go, again, let's go back to the waiver argument. We didn't know about that. We came before this court just a few weeks after this was filed, this full satisfaction of judgment. This was never disclosed to us. We had no idea. We just happened to find it sometime later and before trial. But we had no idea. But this was a fully satisfied judgment. There could be no recovery on that judgment.
Okay.
And if I may go back to what occurred.
Counsel, you ran out of time. I gave you both plenty of time to argue, so, okay?
Thank you.
Let me hear from McLaughlin. I'll give you 1 minute on the cross appeal, and that's the end of it.
I'll be 30 seconds, Judge. The satisfaction was filed. It's ministerial. It does not indicate. It was an agreement between the parties that the Sterling Mets insisted upon with the underlying agreement with the assignment, and the satisfaction does not extinguish the assigned claims by the Mets for their rights of recovery, both as the self-insured entity that paid $1 million, $1,175,000, and also its assignment of its rights for the defense costs of close to $275,000 thereabouts. Thank you, Your Honor.
Okay. Thank you both. East 72nd. Go ahead, counsel, I'm sorry.
Thank you, not at all. Good afternoon, Your Honors. May it please the court, my name is Jonathan Houghton on behalf of the appellant East 72nd LLC. With respect to the lower court summary judgment determination, I'd like to first start with what I refer to in the brief is the Loretto issue, stemming from the U.S. Supreme Court case of Loretto against Teleprompter Manhattan. It is an absolute that when the government takes private property, it is required to pay just compensation. That absolute is not in dispute, and it is agreed to by the MTA, and it is actually proven in fact by the MTA's payment of an advance payment of $125,000. In this case, when the lower court ruled within its decision that the MTA was entitled to physically invade the owner's space and take title to these easements at no cost, the lower court violated this clear tenet of U.S. constitutional law from Loretto. And I think that it is undisputed that just compensation is required. And on that, this lower court's decision must be reversed. The second issue that I'd like to address pertains to the STLUD, which is the transit easement. The lower court held that were the owner to develop the property, it would be required to give property to the MTA pursuant to the STLUD transit zoning section. However, the problem with that determination is that whether or not an owner has to give property to the MTA is a discretionary determination, not a mandatory one. And it's a discretionary determination by the MTA. The fact that it's a discretionary determination means that whether or not the MTA chooses to exercise its discretion is a material issue of fact to be determined at trial. Moreover, the appellant presented evidence that was disregarded by the court that within the special transit district, the MTA only exercised this discretion on 10 out of 65 applications, or 15.4%. And moreover, when it did exercise its discretion, it did so for properties that were larger and for easements that were different. So for the lower court to make this finding as a matter of law in summary judgment was an error. Next,
I thought, explain something to me, that did the MTA show that the property size had no impact with respect to an easement on that underground passageway?
What the MTA did, Your Honor, was present an affidavit from Helene Sequay of the MTA saying that they would exercise their discretion. But it did not specifically reference the size of the property. However, Your Honor, whether or not the MTA would exercise its discretion is something that I should be entitled to explore at cross-examination on trial, because this is information that is solely within the MTA's exclusive knowledge.
Right.
It should not be something that is taken as a matter of law.
Okay.
Additionally, Your Honor, the fact that this transit easement section was for the 2nd Avenue subway project means that the project influence rule applies. In fact, in settlement negotiations, the MTA demanded that we provide an easement pursuant to this transit section for the 2nd Avenue subway project. And that exemplifies the fact that this is part of the condemnation project, and therefore the project influence rule bars its consideration. I would also like to point out, Your Honor, that When the lower court ruled that this would not be an exaction, which is another form of constitutional taking, it found that generalized statements were sufficient. And I see my time is short, so I'm going a little quick, but the law is that generalized statements are insufficient, that the court has to look to an individualized determination with respect to the building that would be built and whether or not there's a nexus and rough proportionality. And I see my time is up, Your Honor, but I would just like to
I'll give you an extra 30 seconds.
Thank you, Your Honor. I appreciate that. I would just like to state, Your Honor, that this rule of law was admitted to by the MTA within its brief, at pages 28 and 32 of its opposition brief. It admitted that this is the law and admitted that this requirement was not satisfied. So with that, Your Honor, I would just simply say that that plus other points within the MTA's brief, I think there are many issues on which the lower court's decision should be reversed.
Okay.
Thank you.
Go ahead, counsel.
Good afternoon, Your Honor. May it please the court. Ken Applebaum for the condemned nor respondent MTA. I would like to address certain of the points that Mr. Houghton raised. First of all, with respect to Loretto, as Mr. Houghton concedes, the MTA paid $125,000 for the easements that it took pursuant to the EDPL. This was a de jure condemnation, as I'll get to later. It's not an exaction case. We had an appraisal. We paid just compensation. So there's absolutely no Loretto issue here. Mr. Houghton also said...
So you disagree with the court that you could have acquired the easements on the property without payments?
Well, no, Your Honor, I don't disagree. Let me explain. In this situation, the court raised that issue about the STLUD and the fact that MTA could have taken it at no cost in the context of how we raised that in our brief. We said that based on the claimant's highest and best use, which would be for a redevelopment of the property, in that hypothetical scenario, the STLUD could have been demanded by the MTA at no cost. Therefore, when you do the before and after approach to valuation, as you must do here, the willing buyer and willing seller would look at the property because it's going to redevelop, according to claimant,
Right.
with the point that the MTA could have demanded an STLUD. In this case, we didn't go that far. What happened was there was no agreement on a development at the end of the day. We had to take the property by eminent domain, and therefore we paid just compensation. So that's basically a red herring, that point. With respect to the fact of whether the STLUD would have been taken in this hypothetical universe, and Mr. Houghton says, well, it's discretionary, I need to have fact-finding on that, the fact there's no issue of fact. There were 3 years of negotiation between Walsum, which was the S&R to the claimant, and the MTA about how we could have a development that would incorporate the STLUD easements. So in the facts here of this case, and there's no admissible proof against this, they were demanding an STLUD. In fact, Walsum acknowledged that and was preparing geologic surveys and architectural plans that would incorporate the STLUD. So there's no issue of fact whether or not MTA would have demanded an STLUD. They were demanding it. That's the fact. There's nothing contrary to that. The other point I would raise, Mr. Houghton raises the project influence rule. The project influence rule, as we brief extensively in our papers, for two independent reasons does not apply here. Number one, the property was bought by Walsum, the S&R here, 33 years after the STLUD was put in effect in 1974. As you may recall, what happened in that prior project is that the MTA was going forward with a 2nd Avenue subway, but in 1975, because of the economic crisis in the city, that stopped. It was abandoned. There was no commitment of funding going forward to it. Nothing happened for nearly 25 years. Then in 1999, as a result of what they call the MESA study, Manhattan East Side Alternative Study, they determined that we need a 2nd Avenue subway. We'll start it from 63rd Street to 96. It was not a continuation of some prior program. It was a totally new program, a new project. And therefore, the STLUD does not apply in a situation when number one, you have two separate projects, in fact, and number two, when the claimant buys the property after the STLUD is in effect. The claimant bought it in 2007. They had knowledge of the STLUD, and in fact, as the lower court pointed out, they don't dispute the fact that they bought the property at a reduced price. So therefore, it would not be prejudicial in any way, shape, or form to say that the STLUD applies here because they bought it with that in effect. I would also like to add, in terms of the very critical point that claimant does not address, we have undisputed admissible evidence in the record from an expert that the proposed development on which they're basing their entire claim, this 19-story development that they say couldn't be built unless you cantilever, that's their main damage claim here. The expert says, I looked at it, I have a 124-page report on it, and I'm telling you there's enough rock there that you wouldn't have to cantilever. They have no admissible evidence against that. All they have is an expert report that says, I assume, the expert says, based on my reading of the easement document, which in this case is the acquisition map, that nothing could be placed on the easement. Well, an assumption does not nullify or contradict an affidavit based on a whole study. And the assumption is based on
So there's no dispute with respect to the sufficiency of the rock?
Absolutely, Your Honor, no dispute whatsoever. And therefore, you have no damage claim for that. The only thing left, if I could just have 30 seconds, is the temporary easement claim, which they say, well, your temporary easement delays our development for 6 years. The Court of Appeals said, when you look at temporary easement damages, the proper way to look at it is retrospectively. What actually happened? If there is no loss, there is no recovery. In this case, there was no loss caused by the temporary easements because at the end of the temporary easement period in 2017, there were still 10 rent-regulated tenants on the premises. You cannot do a development with 10 tenants on the premises.
Got it.
So it caused absolutely no damage in retrospect. And therefore, Your Honor, we respectfully request that the court affirm Justice Schulman's order. Thank you.
Thank you.
Your Honors, briefly, with respect to the rock cover issue, I would note that there is a dispute. We did put in an expert report from Langen Engineering saying that you couldn't build on top. But more importantly, Your Honor,
That you couldn't build on top, or you couldn't build a 19-story structure that you were contemplating?
you couldn't build the 19-story, but you couldn't put on top of the easement or invade the 14 feet where the permanent easement starts.
Okay.
But I'd like to point out, Your Honor, that in these negotiations with the MTA, we provided these plans to the MTA, and Deputy Counsel of the MTA, Tony Szymanczyk, said, I'm not giving you permission to build. You can't. We asked the MTA for permission to build, and he said no. And that is, Your Honor, in two affidavits from Peter Weiss and Richard Bass at 836 and at 845 of the record. So regardless of what the engineer says, it doesn't matter if the MTA says no and the DOB says no.
And there's no appeal? There was no appeal of that decision? You could not object to the decision or appeal it?
That was in what we characterized as settlement negotiations, and the MTA disputes were settlement negotiations, but that was in a conversation with it was not in a formal permit application. But Anthony Szymanczyk said no. So when the MTA says you can build, that's disputed by what the MTA Deputy General Counsel said. With respect to the STLUD, the MTA demanded that we provide an STLUD for the 2nd Avenue subway project. With that, it was error for the lower court to say that it's not part of the 2nd Avenue subway project when the MTA demanded it as part of the 2nd Avenue subway project. It's one and the same. The fact that time has passed doesn't change that, and if they were somehow different, then the MTA couldn't have demanded it. And if I can just have 10 seconds, Your Honor, on Loretto, thank you.
I'll give you 10.
Because
they argue Loretta is not implicated. So why is it?
If the lower court's decision stands, we have to pay the $125,000 back plus interest pursuant to EDPL 304. That's why Loretto's implicated.
Okay.
Thank you.
Yeah.
Double duty today,
Double
counsel?
duty today. Good afternoon again, Your Honors. May it please the Court. Ariel Reed of the Center for Appellate Litigation for Mr. Timothy Grant. Mr. Grant's statement at the District Attorney's Office should have been suppressed because the prosecution failed to meet its burden to prove it was sufficiently attenuated from the conceded patent violation. 4 factors for this court to consider in determining whether the statement was sufficiently attenuated include whether Miranda warnings were given, the flagrancy of the misconduct, the temporal proximity, and whether there were any intervening circumstances to diffuse the taint of the illegal conduct. Here, while there were Miranda warnings given, that shouldn't be given much weight because you would expect that Miranda warnings would be given in every case or in most cases, and if all the police had to do was to avoid the exclusionary rule is to give Miranda warnings, then there would be nothing deterring them from the misconduct that this court...
So are you arguing that this is a continuous interrogation, although initially it was the detective, right? Then DA, he basically, and they changed location, right?
They did change
And he did get some water. Is that enough?
They did change the location, Your Honor, but this was a continuous interrogation. Judge Hong's decision basically distinguished between the interrogation at the precinct and then the interrogation at the DA's office. But looking at his decision, there's really no rationale for such a distinction.
Well, it was 10 hours later, wasn't it? It
It
was
was
10 hours after the arrest, and I think 4 hours after the first statement at the precinct, right?
Yes, Your Honor. It was 10 hours after his arrest at the time he made the second statement. However, he was arrested 5 hours before he made the first statement. And part of the reason why Judge Hong found that that wasn't sufficient was because there was no testimony about what transpired between the time he was arrested and the time of his first statement. Here, there's even...
So 4 hours after the first statement is when he makes the second statement. He makes the second statement at the district attorney's office after the assistant district attorney reads his Miranda warnings. Although the detective is... So we have a different location. We have a different interrogator. Although the detective is present from the first statement, he or she does not interrogate the defendant. And also, during the second statement, there is absolutely no reference to the first statement. So why is that not sufficient attenuation?
Your Honor, the second statement, in fact, does have some reference, at least to Mr. Grant, some suggestion to Mr. Grant that the DA was aware of the first statement. At one point during the second round of questioning, the DA showed him the same photograph that the interrogating detective had showed him back at the precinct and said, "You may have seen this already," obviously knowing that the detective had shown him the photograph. And of course, after the first interrogation, the detective called the DA and told him everything that Mr. Grant said. And so the DA was primed to know what was discussed and what wasn't, and that's why he was able to show the same photograph and tell Mr. Grant, "You may have seen this before, but can you just show me what, where you were?"
But that wasn't some random photograph. It was a photograph that ostensibly had something to do with the incident, right?
Yes, Your Honor, it wasn't a random photograph. However, showing Mr. Grant the same photograph right beside the investigator who had shown him that photograph previously, if you're Mr. Grant in that situation, are you going to say, "I don't know what that photograph is," when the detective who showed it to you maybe an hour ago, maybe not 30 minutes ago, is sitting right next to you and you've already identified yourself when he showed it to you? What choice do you have but to say the same thing you said before? Do
you have any case law or anything that would stand for that proposition? I find that to be interesting because if there is a relevant piece of evidence which would happen to be shown to a defendant during a first interrogation, does that now preclude all interrogators after that from presenting that same piece of evidence?
No, Your Honor. It's not a preclusive or outcome determinative factor. It's one factor to determine when the court is assessing whether there was an appropriate intervention here. And so in totality of the circumstances...
So it comes up in the context of attenuation.
Yes, Your Honor. And
The analysis of it anyway.
yes, along with numerous other factors for this court's consideration. I will
Okay.
reserve the rest of my argument for rebuttal.
Thank you, Ms. Reed. Go ahead, counsel.
May it please the court, Amanda Regan on behalf of the people. I would just like to begin by correcting a slight misstatement of the record. During the second interview, the defendant was not shown the same photograph that he was shown by Detective Rose. Detective Rose showed defendant photographs that had been collected from the defendant's Facebook.
But Detective Rose was present at the second interrogation, right?
He was present at the second interrogation, but he didn't participate in any way
So why did
beyond.
he have to be present? I mean, I understand it's a security issue, but there are other detectives, I think, right? And there might have been another detective that was working on the case, or you could have used some other law enforcement officer. Why did you need to have the same detective who had previously interrogated the defendant present in the district attorney's office?
Your Honor, I don't know why that specific decision was made. However, there are plenty of cases which we cite to in our brief that say, you know, the mere presence of the original interrogator at a second interrogation does not taint the attenuation between the two statements. And like I said, here, Detective Rose said absolutely nothing beyond his name for the videotape during the second interrogation. So the hearing court's thorough and well-reasoned decision was entirely proper. As was already noted, the second statement was made a full 10 hours after the arrest, 4.5 hours after the first statement was made. It was made at a different location, and there was.
So you're saying Detective Rose's presence is inconsequential?
Exactly, Your Honor.
Although, if I understand the argument correctly, is that the fact that he was present, the ADA was doing the interrogation. It was just one continuous interrogation.
It wasn't.
Lasting over 10 hours, where he only got a little bit of water, and that's it.
But it wasn't one continuous interrogation, Your Honor. There were several breaks. After the first initial interrogation, Detective Rose's testimony was clear that the defendant was returned to the holding cells and he completed arrest paperwork. Unfortunately, the record does not note how long that occurred, but that was one significant
Did they
break.
feed him?
I'm sorry?
Did they feed him? Did he have anything to eat?
Those are all questions that go to the voluntariness of the
Well,
defendant's
no, I think those are
statement.
questions that go with whether this is one continuous interrogation. I mean, he gets thrown into the jail so that he can finish some paperwork that lasted we don't know how long, and then he gets pulled out, and it's not Rose who's interrogating, it's the ADA. I'm there, having eaten, all I have is a little bit of water. What am I to believe? You know, I'm getting cross-examined by as one continuous thing.
Well, Your Honor, it was not one continuous interrogation.
I
There
know
were
you say
several
that,
breaks.
but, you know, I'm trying to determine what rationally can be inferred from what took place here.
Well, we do know that he was taken from one location to the other location, right? The holding cells are not at the district.
Exactly. That drive, Detective Rose indicated, took between 30 to 90 minutes, depending on the traffic. He couldn't
Did
recall
they
on
stop
that
for
day.
food?
That's
Never
not
mind,
part
that's
of the record,
withdrawn.
Your Honor. And just turning briefly
Food is
to,
important.
I know, you keep bringing up the food.
turning briefly to counsel's argument, you know, that defendant felt compelled to admit his guilt in the second statement. That argument carries no weight. As noted, defendant was given his Miranda rights. Once more he was read them, he unequivocally waived those rights. He agreed to speak with the ADA, and he actually attempted to.
But you
first-
agree that there's a sort of, I don't want to call it coercive effect, but the reality is Rose is there.
Yes.
He already made some admissions in front of him. Why does he have to be present? If the ADA is asking the questions,
Perhaps he doesn't need to be present, but the reality is there was no, the defendant didn't feel any pressure to make a second admission because he actually tried to exculpate himself at first. He said, I don't want to answer your question as to whether I was holding a gun that day because I don't want to incriminate myself. And then once confronted with the still photograph from the video, the surveillance video of the shooting, he realized that we had, strong evidence against him and then admitted his guilt. Unless your honors have any other questions, we ask that you affirm.
I think we're good.
Thank you.
Your Honors, there's simply not enough factual record here to establish that this was not part of one continuous interrogation, and I want to highlight that that is the people's burden to prove that the statement was attenuated. It's not Mr. Grant's burden to prove that. And in addition to that, while my adversary noted that the second interrogation started, I believe she said 4.5 hours after the first interrogation, we actually don't know that. We know that Mr. Grant read his Miranda rights during the first interrogation at 11:55 a.m. We know that he started the second interrogation at 4:23 p.m., I believe. We don't know what time the first interrogation ended. Detective Rose stated that they took multiple breaks, and he also stated that he took Mr. Grant to the DA's office for his second interrogation, quote, a short time after the first interrogation ended. He wasn't able to say what a short time was, but he did say it was short. And that's just not the kind of record that definitively establishes that these are two separate interrogations. As your honors noted, the same people present, the same subject matter, a short amount of time in between. That's not attenuation.
Okay, thank you. Thank you both. Okay, last, Sakibu versus Diallo. Okay.
Your Honor, good afternoon. My name is Bernard Alter. I represent the appellant Sakabu and Diallo, and the one Diallo. It's hard for me to pronounce that first name. I'll be brief. The court's given us only a few minutes to argue this appeal. There are two issues that I found in the record that I think should be brought to the court's attention, and that is dealing with the issue with respect to payment of petition signatures. There was testimony at the trial that was brought out by Mr. Jefferson and a second witness. The signature witnesses were being paid per signature by the candidates.
But didn't the Board of Election already found a sufficient number of signatures, notwithstanding the fraud that you're claiming?
Each side had enough signatures, no question. There was enough signatures. Both sides had plenty of good signatures with respect to the case. I concede that. Each side,
So you think the permeation of fraud sort of invalidates?
Correct.
That?
That's my argument.
Okay.
Very briefly.
Got you.
I argued it with respect to the issue with respect to the signature witnesses. There was testimony at trial that they were getting paid, and the person who paid them, the paymaster, who was the petitioner in this case, Burns, did not get called to testify.
But they weren't being paid per signature. They were being paid for the day, right?
Not according
I thought that was what the testimony was, that they were being paid for the day. It's not like you bring us 50 signatures, you get $100. You bring us 500 signatures, you get $1,000.
According to the trial testimony, and I've cited it in my brief, Your Honor, it appeared clearly that Mr. Jefferson was being paid per signature. He said, I would get $300 if I collected a certain amount of signatures, and $100 if I collected a certain amount of signatures. That is his testimony, and I cited that in the record. It's in the trial transcript. And the same thing with the second witness, and the person who did the payment didn't testify. So that's my issue on that case.
Okay.
The second issue is, with respect to my adversary's case, according to what the referee said, there was no proof with respect to fraud against my clients. In fact, no testimony came in. I think they claimed 4 signatures were bad. There was no proof as to how these signatures were being collected or the manner in which they were being collected. The Saul case makes it clear, and the appeals courts make it clear, that you have to have a clear and convincing evidence case with respect to fraud. And I feel that the other side did not prove fraud, and in that respect, the referee's decision is correct.
Okay.
That's it for me.
Thank you. No, that's it. No rebuttal. I mean, we would have given you more time, but the request was made like at the last second. Notwithstanding the fact that the clerk's office kept asking you, are you going to argue, you're going to argue, you're going to argue? And we got to be...
I understand that was done at the last, this whole case came out real fast.
No, I realize it. All election cases, that's the nature of the beast, right?
You know what happened on this one, it was decided very late.
Okay, all right.
That's why we're here today.
Let me hear from the other side.
May it please the court, Mr. Alter. I represent the respondent and cross appellants Amadou Diallo and Celeste Burns. And, Your Honors, I just want to clarify that there is absolutely no proof that any signatures were gathered per signature, that any petitioners were paid per signature, and that proof is brought out in the testimony where Max Jefferson said that he would be paid $100 to $300 depending on how many signatures he collected. He never said that he was paid per signature, and you know...
This was an issue before the referee and before Judge Carter, wasn't it?
An issue before the referee, and it was before Judge Carter, and the referee, in fact, opined that maybe he was just being paid to collect more signature as an incentive. And there's nothing that says what he was paid per signature. And not only that, but Joanne Harden was paid after she collected petition signatures and said that she never knew that she was going to get paid. And the notion that these petitioners were paid per signature is just false. There's no record anywhere in the testimony. There's no testimony anywhere that says that they were getting paid by signature and that
So, counsel, what is our review? What are we reviewing? Are we reviewing what Judge Carter decided and what the referee decided?
Judge Carter credibly decided that these witnesses, for one thing, he decided that these witnesses were credible and that there was no testimony that said that they were being paid per signature. And in fact, even if you were to invalidate Max Jefferson, you can't permeate.
So the issue is whether or not Judge Carter, we accept Judge Carter's determination as to what the record was. Is that correct?
Well, that's correct, Your Honor. Your Honor, the referee's report actually found credibly found that these witnesses were not being paid per signature, but this was upheld by Justice Carter. And, Your Honor, there's nothing that can indicate permeation of fraud just based on the testimony of one person who said that he would be paid $100 to $300 a day, depending on how many signatures he collected.
Thank you. Thank you, counsel. Thank you both.
All persons having tagged business with the appellate division may now depart. This court announces a recess. Please remain standing.